Real Properties versus Jasmine Brown.
Before this hearing even starts, you can already tell this docket is moving at lightning speed. Today, Judge Simpson is handling a string of eviction and possession cases, and every defendant walking into this courtroom is standing at a crossroads: pay, negotiate, or risk losing their home. That's the brutal reality of housing court. What makes this especially intense is that most of these people aren't fighting over whether they owe money. They're fighting over whether they can catch up in time. Watch how the judge handles these cases. He's not just enforcing the law, he's testing credibility. Can these tenants actually follow through? Or are these promises just buying time? That's the tension driving every moment here. And trust me, some of these cases take emotional turns you won't see coming. Pay close attention to the deadlines, because in this courtroom, one missed day can change everything.
Daniel Landman on behalf of the plaintiff, Your Honor. I believe Ms. Brown is present.
Yes, and also
I'm here.
Deontay McDaniel. Yes, ma'am. All right.
Good morning.
What? Good morning. What is plaintiff's claim in this case?
Your Honor, plaintiff's claiming rent to retain of $843.68 and costs of $214 for a grand total of $1,057.68.
And ma'am, how are you intending on getting this paid?
I'm working with
I need a camera, ma'am, if you
okay.
can.
Hold on. Well, let me see. Okay. Can you see me?
Okay, there you are.
Okay.
Yes, ma'am.
So yeah, I'm working with SOS. I had called Hawk and they put me through the SOS. So my caseworker that I was working with, she got sick. So it should be paid by next week, basically.
Okay. By next week, will you pay it before what time?
12 noon.
Can you get that paid before noon on next Friday?
Yes.
You think you can? All right.
Yeah, I think, yeah. Because I already went through everything. She just was sick. So it was Elizabeth Fink is who I'm working with.
Okay, very good. So what I will do is I'll adjourn this out to 26.
Yep.
To September 26, 2025 at noon.
Okay.
This is a classic judicial pause button. Instead of granting possession right away, Judge Simpson gives Jasmine a narrow window to fix the problem. But make no mistake, that's not mercy without conditions. She owes over $1,500, and now the clock is officially ticking. What's interesting here is Jasmine's reliance on SOS and a sick caseworker. That's a real-world issue courts see all the time. Assistance exists, but bureaucracy moves slow. The judge seems willing to trust her, for now. But if that money doesn't hit by next Friday at noon, this case flips fast. That's how eviction timelines work. A promise buys time, not protection. Here's the question. If your housing depended on a third-party agency moving fast enough, would you feel secure or terrified?
Okay, if that's paid and you make sure that it's paid, you won't need to appear. Otherwise, that is an in-person hearing.
Okay.
So you'll have to come down to the courthouse if it's not paid.
Okay.
Okay?
All right. Thank you. Have a good one.
All right, you too. Real Properties versus Teresa, is it Egems? And also Terry Egems.
Daniel Landman appearing for the plaintiff, Your Honor. At least one of the tenants is present.
There's only one tenant. It's Teresa Igems, and Terry is my nickname.
Okay, very good. All right. So you're Teresa.
Correct. And
All
Terry.
Right. And Terry. Okay. So, well, my issue is that I have two defendants.
Right.
I'm not sure why that.
And I'm trying to figure that out as well, Your Honor. I'm checking the lease.
They just have both names.
Okay. And your preference on which name is?
Terry.
Terry? Okay. I will try to remember that for the next time. So, all right. All right. What is plaintiff's claim in this case?
Your Honor, plaintiff is claiming rent to retain of $1,926 and costs of $214 for a grand total of $2,140. In a chat prior to your taking the bench, I believe this tenant indicated that she was seeking state emergency relief.
That's correct.
All right, so you are doing an SER?
Yes, and I also have an
Hey.
appointment with SOS on Tuesday, this upcoming Tuesday.
This upcoming Tuesday, the 22nd, 23rd?
I believe so, yes.
All right. So two things. How many people are in your unit?
Just one.
Just one? Okay, so just so that you know, and that if an SER is granted, that's only going to net you about $410. And the other amounts would have to be paid prior to them paying that, so that you're aware of that. Okay?
All right.
This right here is the financial reality check. Teresa owes over $2,100, but the relief she's hoping for only covers a fraction. That's a huge legal and practical problem. A lot of tenants enter court thinking emergency aid wipes the slate clean, but it rarely works like that. Judge Simpson is being direct here, and honestly, that clarity matters. Because if Teresa misunderstands the numbers, she could walk into the next hearing unprepared and lose possession. And then there's the paperwork. The rental assistance form isn't optional. It's procedural survival. Miss that deadline, and the court may treat it like you're not pursuing help at all. That's how technicalities become life-changing. The question is, should emergency housing aid be enough to actually stop eviction, or is this system setting people up to still fall short?
All right. The other thing is, in your packet that you received from the court, there is what is called a rental assistance form. You'll need to fill that out, put your SER tracking number on there, and supply that to the court by next Wednesday.
Okay.
All right. And I will adjourn this out to September 26, 2025 at 12 noon. That's an in-person hearing, ma'am. Is there any payments that you can make between now and then?
Not at this time, no.
No? Okay. All right. Very good. Then we'll see you then, and then we should hopefully have some news regarding everything else. All right?
Okay, thank you.
Thank you. Evergreen Apartments versus Carnell Harbin.
Good morning, Your Honor. Parissa Gazeri appearing for plaintiff.
Good morning.
I have not checked it.
They are not checked in. If you'd like to take a default, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead.
Thank you. This is an action for non-payment of rent. The rent to retain possession is $3,012.39. Court costs of $172 for a total redemption of $3,184.39. Plaintiff is requesting entry of a default judgment for possession with a writ to issue after 10 days if the total amount remains unpaid.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested with the writ to issue in 10 days.
And there it is. Default judgment. Fast, clean, devastating. The defendant didn't show up, and in housing court, that silence speaks loudly. Legally, once the landlord proves the balance and the tenant is absent, there's usually very little stopping the court from granting possession. This is why simply showing up can be powerful. Even if you don't have money, your presence can buy time, open negotiation, or delay enforcement. But absence? That usually closes all those doors instantly. What's wild is how differently this could have gone if the tenant had logged in or appeared. Instead, now there's a 10-day countdown before the writ can issue. That's the final stage before removal. Missing court might feel small, but in cases like this, it can cost everything.
Evergreen Apartments versus Markayla Jennings.
Parissa Gazeri for plaintiff.
Ms. Jennings?
Hello?
Hello. Good
Can you
morning.
see me?
Yes, ma'am, we can.
Okay.
All right. And what is plaintiff's claim in this case?
Your Honor, the outstanding balance is $3,039.09, which includes court costs.
3,039 and how many cents? I'm sorry.
9.
9 cents. Thank you.
Mhm.
All right. And Ms. Jennings, how are you intending on getting that paid?
I know I'm gonna pay $850 today.
Okay. You're going to pay 850 today? Okay.
I only get paid every 2 weeks.
Okay. This is your pay week?
Mm-hmm.
All right. Okay. Have you tried to work out something with the landlord or seek assistance?
No, because Sydney typically doesn't give any like plans or anything.
I'm sorry?
I told her I should have it all paid up by mid-October, but she just said go to court. So
All right, so your part of your plan is that you get it, everything paid, including your October rent paid by mid-October?
no, it's October included by the end of October.
I'm sorry?
My old balance by mid-October, but October by the end of October.
Got it. I see what you're saying, because you need that next paycheck to try to clear that, right?
This is one of the stronger defenses we've heard, not because she disputes the debt, but because she has a structured timeline. Judges often look for something simple. Is the person organized, honest, and realistic? Jennings sounds like she is. She's already committing $850 immediately and laying out future paychecks. But the landlord isn't obligated to accept that. That's the cold part of landlord-tenant law. If there's no agreement, the landlord can still push forward. Judge Simpson's move here is strategic. He creates a one-week bridge. That gives both sides time to negotiate. That suggestion to call the attorney's office, that's where deals often happen, not in court, between hearings. If you were in Jennings' shoes, would you trust the landlord to work with you or expect them to push for eviction anyway?
Okay, so I'd suggest that you talk or call the attorney's office, see if something can be worked out. If it can't, what I'm going to do is I'm going to adjourn this to next week. That'll be September 26, 2025 at 3 p.m. That's an in-person hearing, so you'll need to appear at the courthouse, okay?
Okay.
Okay, get the $850 paid to them, however. All right?
Okay.
Okay, thank you.
Thank you. Bye-bye.
Gulfside Lake 3. Is that how that's okay? That's not how they're labeled. Gulfside Lake 3 versus Jonathan Henderson.
Marissa Gazari for plaintiff.
Jonathan Henderson?
Yes.
Okay, there you are. Okay, good morning.
Morning.
Okay, what is plaintiff's claim in this case?
Your Honor, the outstanding balance is $3,077.31, which includes court costs.
All right. And sir, how were you intending on getting that paid?
Right now I certified for, well, I put in an SCR request also, and I certified
Okay.
employment. I haven't been paid out unemployment yet, and that's something I'm working through. So I will know something from that by next week. But I will be able to pay something on the amount next week also. I'm not sure how much it will be, but it will be at least $1,500.
You think you can pay $1,500?
Possibly.
That's an estimate, but sometime next week.
Yes.
Can you do that before next Friday? Or is that going to be?
I'm hoping to do it by the 23rd, but Friday is very possible.
By that Friday?
Friday by noon, yes.
Okay, so you think you can pay it by the 26th at noon? Okay, so I'll put that down in there. With reference to your SER, how many people are in your house?
Just one.
All right, so if that's granted to you and they do that, you'll need to know that that only will account for about $410.
Mm-hmm.
Okay, so they aren't covering a large portion of it, and they would require that you pay everything else before they're going to pay. You follow me?
Jonathan's case shows the dangerous gap between aid expectations and reality. Over $3,700 owed, but relief might only cover around $410. That's barely enough to move the needle. And on top of that, his unemployment hasn't even come through yet. So legally, he's standing in court relying on money that doesn't exist yet. That's risky. The judge knows it too. That's why he keeps pinning him down on exact dates. Possibly, and hopefully, don't mean much in legal proceedings. Courts need concrete commitments. What saves Jonathan here is that he's present, engaged, and at least trying to outline a path. But whether that path holds, that's another story. Here's something to think about. Should courts consider pending unemployment benefits as a valid sign of future payment, or is that too uncertain?
Just pay it as such.
Okay. So the other thing is that in your packet, you'll see what's called a rental assistance form.
Mm-hmm.
That rental assistance form needs to be filled out. The tracking number for your SER needs to be put on that form, and that needs to be submitted to the court by next Wednesday.
Okay.
Okay?
So I
I'll
have,
adjourn it.
so I have to
Go
bring-
ahead.
I'm sorry to interrupt. I'm listening.
No, go ahead.
Oh, so I have to bring that into court or I mail that in?
Yes, that has to be in the court by Wednesday with your tracking number on it. Okay? All right. So I'll adjourn this matter to September 26, 2025 at 3 p.m. If everything is not paid, sir, that's an in-person hearing. You'll need to be down at the courthouse, okay?
Yes, sir.
All right. Thank you. Hillside Lake versus Natasha Olmos.
Marissa Gazari for plaintiff.
Hi, I'm here. How are you?
I'm good. You were on camera. There you are. Okay.
Hi.
All right. What is plaintiff's claim?
Your Honor, the outstanding balance is $2,125.57, which includes court costs.
And ma'am, how are you intending on getting that paid?
I have an SER application in. I actually just got out of inpatient rehab that you sentenced me to. I have my certificate right
Yes.
here.
Congratulations.
Thank
Fantastic.
you. I'm happy to be home. So I've been gone for almost 6 weeks now, so I haven't been able to work, but I do have pending child support that was paused while I was in there because their dad had them. And then I also have pending unemployment benefits. So I plan on, I've already put the SER application in. I'm communicating with some other agencies as well. And I plan to get that paid as soon as possible, as soon as they approve my application, but it's pending right now.
All right. So how many people are in your house when your children are with you? So
5.
5? Okay. So the
Yep,
maximum
5
amount.
including myself.
Okay. The maximum amount in SER will pay will be $870. Okay.
Okay.
All
All right. And
the
I'm working
other
with other
thing-
agencies too as well.
right. Miss Olmos, just listen to me for a minute. Okay. Let's see if we can get some assistance because you're trying to get yourself back on your feet and straighten things out outside of yourself, right? Right now.
Yes.
Okay.
This moment hits differently. Natasha's not just behind on rent, she's fresh out of rehab, rebuilding, and trying to reconnect with her children. And Judge Simpson knows it. That history changes the atmosphere completely. You can hear it. Instead of pure legal mechanics, the court shifts towards support and recovery. He introduces Rising Hope, which could connect her to housing resources because of her criminal justice background. That's significant. It shows the court recognizing that stability isn't just about rent. It's about recovery, family, and reintegration. But the debt still remains. Compassion doesn't erase the balance. It just buys opportunity. That's the tension here. Can someone rebuilding from rock bottom catch up fast enough to satisfy the legal system? That's not just a courtroom question. It's a life question.
So first thing is, because you filed an SER, there's a rental assistance form in your packet. You'll need to fill that out, put the tracking number of your SER on that, and get that to the court by Wednesday.
Okay.
Okay?
Now, can I email that or
And-
bring it in?
Yeah, you can email it. You can email it to the court. Okay?
Okay.
And then the other thing that I want you to do is we have a court liaison officer and there's a program, I think that is called Rising Hope. And so I want to try to tie you into that. If you qualify for it, I can't be sure, but it's to assist with housing in some way. I'm not entirely clear on everything for those that have been impacted by the criminal justice system. Okay.
Oh, awesome.
All right. But I don't know if that's just Section 8 certificates or exactly what it is. So I'm not clear, but we might as well give it a shot. Okay.
Okay, what's it called again?
The program is called Rising Hope, and I'm going to let you talk with Amy, and there may be other resources out there. She's our court liaison officer, so she may be able to get you in touch with things. All right.
Awesome. Awesome. Thank you.
You're doing well, though.
Very well. I'm happy to be home.
Okay. All right. I will adjourn this out to September 26, 2025 at 3 p.m. That is an in-person hearing, so you'll need to come down to the courthouse if everything is not paid, okay? And then
Okay,
we'll see
sounds
where
good.
we go. We'll see where we go from there, okay?
All right, thank you.
All right, hold the line one moment. Amy, I know you were there.
Good morning, Your Honor. I am.
Yeah, all right, fantastic. We're going to put you in, I think you were probably listening. We're going to put you into a breakout room with Miss Olmos. She's a good person. She's been doing the work. So we had our run-in with each other, but I think she's good. Okay.
I'll be happy to speak with her. Thank you.
All right, we'll put you into a breakout room. We'll see you next week, Miss Olmos.
Perfect, thank you.
Gulfside Lakes versus Lucia Williams.
Carissa Gazari for plaintiff. I think there's one other defendant as well.
There is. And Karan Williams. They are not present. You may proceed.
Thank you, Your Honor. The rent to retain possession is $1,884.56, court costs of $214, for a total redemption of $2,098.56. Plaintiff is requesting entry of a default judgment for possession with a writ to issue after 10 days if the total amount remains unpaid.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested, writ to issue in 10 days. Court does call the case of HP Foreclosure Solutions versus Adam Henry.
Good morning, Your Honor. Adam Devlin, P72877 for the plaintiff.
Adam Henry, they have not checked in, and I think you paid for second service on this.
We did, Your Honor.
All right. If you'd raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do swear, Your Honor.
All right, go ahead.
Your Honor, this is a complaint for possession after a failure to permit an inspection subsequent to a foreclosure by advertisement. My client was a successful bidder at the auction. Sheriff deed is in the file. Our notice requesting an inspection from Mr. Henry with proposed dates and times is included in the file as well. We have not heard from him. He has never called to schedule an inspection. This was served under MCL 600-32-7 and 32-38 pursuant to the Summary Proceedings Act. He has not responded or otherwise defended. We're asking for default judgment, possession only to enter, writ date of the 29th of September. I will email that to your clerk.
All right. Judgment to the plaintiff. That is by default for possession, no redemption amount, writ to issue 10 days.
Thank you, Your Honor.
Thanks.
This case is legally tougher than the rent disputes because it's post-foreclosure. That means ownership has already shifted. The plaintiff isn't chasing rent. They're enforcing possession rights after allegedly being denied inspection access. That's a major difference. There's no catch-up on rent option here. Once foreclosure reaches this stage, the occupant's leverage shrinks dramatically. And since Adam Henry didn't show up, there's no resistance at all. No defense, no explanation. That makes this almost automatic. The court grants possession, and unlike the rental cases, there's no redemption amount attached. That's important. It means this is about control of the property, not debt repayment. And once that writ issues, the clock is brutal. Do you think foreclosure law gives enough warning before people lose their homes?
Thank you, sir. Court does call the case of Maple Heights Apartments versus Tabitha, is it Tangeman?
Yes, sir.
Morning, Your Honor. Alex Tolson on behalf of plaintiff.
And this is a non-payment of rent case. What is plaintiff's claim?
I show rent outstanding in the amount of $1,680, court costs of $170.05 for a total outstanding balance of $1,850.05.
We have all of it.
I have all of it.
Ma'am, how are
Yes,
you
sir.
intending on getting this paid?
I have it right now. I have it with me. I tried to turn it in today, but nobody was in the office today. But I promise I have it in full right now, right here in my hand.
Okay, all right. Okay, hold on. Here's what you do. Is somebody going to be in the plaintiff's office today?
No.
You know, counsel?
Anton, are you on? Is someone going to be in the office this afternoon, or does she need to drop it in the Dropbox?
See,
18.
Yeah,
you can drop it off in the night drop. That's no problem. I'll run it on Monday morning.
All right, very good. All right, so you're going to put it in the Dropbox?
Can I say something really, really quick? Totally respectful. The only thing I have against the drop-off box is I've put my rent in a drop-off box. I mean, it was a couple years ago, but I put my rent in a drop-off box and it disappeared. And it was a whole big case about like I let PK Housing know. I let them know, hey, look, I paid it, I put it in there. I even took a picture of it, and then it went missing. And then they tried to take me to court for it, knowing that it went missing. And it was a whole big thing. I had to call the MoneyGram back, get them to void it, to send it back. So I just try to hand it to them in person. That way I know that it's turned in. I mean, is it okay with you? Can I turn it in Monday morning first thing? Or do you want me to put it in the drop-off box? Because I just get scared to put it in there. I don't want it to go missing because it's a lot of money.
Somebody will be there Monday morning?
This is a trust issue, and honestly, it's understandable. Tabitha says she has the full amount right now, which changes everything legally. Full payment can stop an eviction cold. But her hesitation? She's afraid of the payment going missing because it happened before. That's not paranoia. That's experience. And to the judge's credit, he listens. He doesn't dismiss her concern. Instead, he finds a practical solution. Pay in person Monday morning. That flexibility matters because it protects both sides. The landlord gets paid. The tenant gets proof. This is one of those rare moments where procedure bends just enough to make sense. But there's still pressure. She's now made repeated promises in open court. If she fails after this, her credibility could collapse instantly. Would you trust a drop box with nearly $2,000?
Correct. I believe that's what Anton indicated.
Yep, I'll be there at 10 o'clock.
Ma'am, get it paid Monday.
Yes, sir. I have it
All
right
right.
here. I have it in full, and I promise.
I will adjourn this matter out to September 26, 2025 at 1 p.m. That's an in-person hearing, but if you've got everything paid, just make sure to double check with them that they've got it. If you got everything paid, you do not need to appear.
Okay, yes, sir. Thank you so much. I promise I will
All right.
have it first thing in Monday morning.
All right, fantastic. Thank you.
All right, thank you so much, sir.
Thank you. Maple Heights Apartments versus Nicolette Burnham.
Alex Tolzman on behalf of the plaintiff. This one will be a dismissal, Your Honor.
It is. Okay, this case is dismissed. That's without prejudice. Plaintiff's request.
Thank you, Your Honor. Have a
Ready?
nice day.
That's it. You do the same. Pine to Clover Lane versus Evan DeCossin.
Good morning, Your Honor. Brent Tinger for the plaintiff, P80491.
Can you hear me now?
Yes, we can hear you now. Okay, very good.
Lovely.
All right, what is plaintiff's claim in this case? Right now, there is rent owing of $28.43 and 48 cents. There's court cost of $175, leaving the balance as of today at $3,018 and 48 cents.
Sir, how are you intending on getting that paid?
I'm literally just waiting on a paycheck, a check away from that. I had some automotive issues that put me a little bit behind.
All right. So you're gonna get this paid in full when you get that paycheck, or what are we talking?
Yeah. It'll be about a week or two, and then I should have everything.
Okay. When is you're waiting to get paid? Is that the issue?
I'm waiting on my next check, sir.
Okay. When is your next check?
It will be. Hang on. It would be the 29th, but likely I can get that sooner.
All right. Here's what I'm going to do. I'm going to adjourn this to September 26, 2025 at 12 noon. Okay.
Sorry, can you say that again?
Next Friday, the 26th at 12 noon. That is an in-person hearing, so you'll have to appear at the courthouse unless everything is paid.
Okay.
All right.
Yes, sir. Thank you.
Thank you, Judge.
Thank you, sir.
And that wraps up today's courtroom docket. And what a lesson in housing law this was. Across all these cases, the pattern is clear. Show up, have a plan, and know your numbers. The people who appeared got time. The people who didn't? Default judgment, fast. Judge Simpson balanced firmness with opportunity. But deadlines ruled everything. We also saw how emergency aid can help, but often not enough. That gap between assistance and actual debt is where many tenants fall apart. And beyond the legal side, these hearings showed something bigger. Behind every case is a real person dealing with job loss, rehab, bureaucracy, or simple bad luck. But the court still moves. That's the system. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.